On Atlanta News First Plus, I'm Joy Lim Nakrin, joined by attorney J. Edward Shipp, joining us once again. Thanks so much for being with us, Jay.
Thanks for having me.
Okay, so I want to just share with our viewers this news that we have been following, and this news just breaking a short time ago. Which is that the Fulton County DA, Fani Willis, has filed a motion to stop leaked Trump plea bargain videos. So essentially, the DA's office has filed this emergency motion. It happened late this morning to stop the distribution of these videos that had been leaked, and they are related to former President Donald Trump's historic racketeering indictment. Of course, initially it was Mr. Trump and 19 co-defendants who had been charged. Of course, 4 have reached plea deals. But as part of the plea deals, there were some videotaped conversations. So all of this latest development comes after actually several media outlets, both national and local, reported on these videotaped conversations from Sidney Powell, Jenna Ellis, Scott Hall, and Kenneth Chesborough as part of plea deals that had been arranged with the Fulton County District Attorney's Office. And I guess the videos appeared to show the president really was kind of determined not to leave the White House despite losing the 2020 general election. So there was this order filed to have basically this information sealed. I guess the new protocol is going to be for the defense attorneys, well, not to have the opportunity to obtain discovery materials in the normal sense, where receiving videos and whatnot, but actually to come in and to the DA's office and take notes and so forth to prevent further leaks. And it was something that DA Willis characterized in the filing as essentially the leaks being something meant to, I guess, in a way, intimidate witnesses. J. Edward Shipp, what is your take on this? And feel free to chime in. I know you've read a lot on this, the filings and so forth. Feel free to chime in also if I'm missing some important details here.
Okay, so what we have today is, excuse me, we have an emergency filing. District Attorney Willis is asking for her September 27th filing to actually have a ruling issued upon it. She filed a September 27th filing asking for a protective order of discovery materials because she most likely saw what is happening right now. She had a premonition about it. She saw that this information, if received by people who were not necessarily holding themselves to the same standards of ethics as her office, they would most likely send out this information, distribute it to the public in the attempts to try to sway witnesses or even sway the public. If you get to a point where you are able to sway the public, you may have situations where supporters of former President Trump may try to intimidate these witnesses by threatening them, their families, even getting in touch with their jobs or anything like this. So she had a motion filed on September the 27th. It was never ruled upon. Now she comes and files an emergency motion to hurry up and get a ruling done on this, and she's asking for them to not be able to send out this information because she doesn't want a situation in which other defendants can be swayed away from testifying and being witnesses in this trial.
And just kind of reading part of the filing, so I'm just reading from the document itself. She writes in part, the release of these confidential video recordings is clearly intended to intimidate witnesses in this case, subjecting them to harassment and threats prior to trial, constitutes indirect communication about the facts of this case with co-defendants and witnesses, and obstructs the administration of justice in violation of the conditions of release imposed on each defendant. So I want to ask you, first of all, do you think that there's truth to this claim, that it's meant to intimidate witnesses, and if not, I mean, or if so, why would someone on the defense side release these videos?
That's a great question. I think that it is truthful. I mean, the proof is in the pudding. We've seen it not only in former President Trump's criminal trials, but also in his civil trials up in New York. I mean, we're seeing where the court clerk, or excuse me, the law clerk is being basically threatened by his supporters, her family. You're seeing even Jack Smith on the criminal side, his family is being threatened. He's being threatened. So by releasing this information, it begs the question of, as you asked, why would they do this? And nothing else points to the solution that they're doing this in order to get other witnesses to say, okay, you know what, I don't want to deal with the other supporters, harassing my family.
I don't want Trump supporters coming after me, essentially. That's really...
Exactly. That's exactly what we're looking at. And, that's a dangerous precedent to set by releasing these proffers and releasing what is supposed to be, protected testimony. But that's what it looks like.
Because typically during, before trial, you have discovery, right, where each side, basically gets information or gets to preview the evidence of the other side, right?
That's correct. So Georgia has, for the criminal cases, they have what is called reciprocal discovery that you can opt into. And the state is supposed to give you over all discovery, all evidence that they have. And you are supposed to do, as the defendant, you're supposed to do the same in kind, which is turn over any evidence you may have as well.
And this is all supposed to remain confidential, right?
Correct.
And I'm not sure if that's something, I know that, kind of by protocol and by tradition, it remains confidential, but is that, I guess legally required? I mean, why the need for this order?
So that, let's segue into that. So this protective order is basically, I don't want to say codifying it, but it is making it whereas if you violate this, you are in contempt of this order by saying do not give out this information to anyone else. Normally, by tradition, you don't see people give up.
Just bad faith.
Yeah.
To share this information that was given to you from the other.
You don't see that too quickly.
But I guess it happens. We see.
It happens.
Okay. So what do we expect now going forward now that we've got this development today?
We will most likely see the judge issue a ruling on it. I'm guessing that District Attorney Willis would like for him to go ahead and impose that protective order to keep this from happening again. And if it does happen again, then those parties in violation of it will be held in contempt. However, judge may say, this is for the best of the public to see all of this, so I'm not going to issue a protective order at this time.
Yeah.
And at that time, we may see more information being leaked out.
Well, there's a lot to follow, and it's such a high-profile case that, I guess it's not that surprising in some ways that there would be leaks here and there, but something that really shouldn't be happening when it comes to this judicial process.
Correct.
The discovery process. All right. Thank you so much for your comments on that. I also, want to turn our attention to, of course, another major trial here in Fulton County, Georgia, the YSL trial, or Young Thug trial. When we talk about YSL, part of the dispute is, what does YSL stand for? Of course, prosecutors say it stands for Young Slime Life, a gang. An alleged gang. That's what prosecutors say. And on the other side, you got defense attorneys saying YSL stands for Young Stoner Life. This is a record label. It is not a gang. And this is an important talking point because at issue are racketeering charges, essentially charges that this was a gang, right? I mean, that's,
correct.
To put it in layman's terms. And you've got these individuals who are charged with not just racketeering, but several other associated crimes. And we've seen most of the defendants plead guilty to charges varying from drug charges to weapons charges to even carjacking, and assault, and numerous other charges, and of course racketeering being one of them. But one of the major issues in this case is rap lyrics, and that controversial ruling by Judge Earl Glanville, who we had just seen in this video. Here's Mr. Glanville. I should say His Honor.
The The honorable.
The Honorable Glanville, that's it.
There you go.
Yes, yes. It was a controversial ruling that he is allowing some of the rap lyrics to be used as evidence of guilt, evidence of racketeering, being a gang, essentially. So I want to ask you about that. I'm going to pull up this playlist that we have where we can actually look at some of these lyrics.
Okay.
Because I want to ask you because, I have questions myself about whether some of these lyrics are any evidence of wrongdoing. Okay, so I'm going to take this off so you can see.
Okay.
All right, well, so here's some of the lyrics where it looks like, maybe more more direct evidence. Okay, tell me what you think of these lyrics that you're seeing right now.
So one thing that we have to keep in mind is the context of hip hop and rapping itself. Rap, hip hop, whatever you want to call it, has always been a thing, whereas it's a game of showmanship. It's a game of being a braggadocio. It's a game of, trying to make people think that you were something that you were not. I mean, you had the Sugar Hill Gang rapping about their color TV back when no one had color TVs in their house, at least back in the early 70s.
Okay.
It was one of those things that you just try to put on for other people. So keeping that in mind, you see the first thing that we have, hey, how you doing? I'm Yak Gotti. I got bodies on bodies. Is that a truthful statement, or is that someone just trying to make it seem as if they are a tough guy? Are they saying, yes, I've actually murdered multiple people and now I'm coming in the studio to, make a song about it? Or are they just saying, hey, I'm a tough guy, don't bother me when you see me out in the streets of Atlanta or wherever? Because a lot of times these guys are targets for robbery and whatnot.
I mean, and then you look at the next one, I'm like, does that could have a totally different meaning. That could have a sexual, you know what I mean?
Correct.
I shot at his mommy, now he no longer mentioned me. I mean, he could be talking about, I hit on your mom.
Exactly.
Like as in
Exactly.
flirted with your mom or something, made a pass
Right.
at her. And it could, to me, it's like, I find it a little bit problematic, not to editorialize. This is evidence of,
Right.
an alleged crime. Just a question.
It's a reach. It's a reach in many instances. I mean, I shot at his mommy. Now he no longer mentioned me. Is he mentioning you on Twitter? Are you talking about, sending a DM to his mom saying, hey, you're cute, whatever,
Exactly.
what have you. And now he no longer mentions me on, X, formerly known as Twitter.
Right.
So, it's a reach. And I think what the defense attorneys are going to do in this particular case is show how much of these lyrics are a reach, how they can be changed up, and how they can have different connotations depending on the background in which the listener came from.
Yeah, and I was looking at some of the lyrics that, let's see, I don't know if we have all of them. I guess they're not all popping up on the screen. I'm having a little bit of trouble trying to get our system to show you some of the written lyrics, but I mean, let me just read
I think
some.
one of
go
the
ahead.
lyrics was about I have a 4-4 and I shoot at your door or something like that.
Mm-hmm.
That's a line from a Notorious Big song. That's what it's called. I mean, you could call it sampling, you could call it biting, you could call it whatever. But it's one of those instances in which, it's a reach. But Notorious Big said this way back in '95. Was he actually shooting at somebody's door? Probably not. So, all of this needs to be taken in the correct context. You don't necessarily need to read these in a vacuum and say, okay, this person actually did it. I mean, we're not prosecuting Carrie Underwood for
Right.
scratching somebody's car, so why would we do this to, this young man?
Well, I mean, and I'm looking at this and I'm like, I don't even see a connotation here. Like, I'm at the top, bro, head honcho. I mean, that could be like I'm just a boss, of a
Right.
record label or just
Right.
in life. You know what I mean?
Right. And maybe we'll get a chance to talk about this a little later, but we need to keep in mind that YSL is also the name of Yves Saint Laurent. You have a lot of rappers that have taken the names of their favorite
brand.
brands and things of that nature, and
Yes.
made it into their persona. You have Gucci Mane,
Exactly.
you have YSL, you have all these other rappers who have come up and said, okay, I like this brand. This is going to be my thing. I believe they may have even gotten a cease and desist from Yves Saint Laurent about this.
Interesting.
So, it's everything has to be taken in context. And
I mean,
it's interesting.
No, absolutely. Well, here and then I'm looking at another one. I rep my life for real for slimes. I kill. I mean, so many people say, I would kill for that pair of shoes. I would kill for that job. Whatever. You know what I mean?
Right,
That's
right.
like such a colloquialism.
Yes.
I just struggle with how the prosecution. Obviously the judge has ruled that it is admissible as evidence of criminal activity. But do you think that it's really going to help the prosecution, or do you think they're really going to struggle to, argue to the jury that it's really relevant?
Knowing the defense attorneys as I do, I don't know many of them personally, but I have seen their body of work. I think what the prosecution has done has set themselves up for their own trap. They're going to find themselves having to explain why these certain lyrics mean one thing and other lyrics have absolutely no meaning whatsoever. Just as you mentioned, I'm the head honcho. Everybody calls himself a boss or a king nowadays. I'm the top capo. People say these things, especially in African American vernacular, which is, again, I think that they're taking this out of context. Slime has been around for years. I mean, there were rappers up in New York who were using this way back when. You have Nori, you have Vado, rappers like that who called each other slimes, and then it made its way down to South Atlanta, and now it's all of a sudden it's okay. Well, that's prima facie evidence of them being in a gang. I don't think that's going to click with the jurors, and they're going to, most likely see right through that.
Yeah. Well, it's going to be interesting. And just a reminder for our viewers, opening statements in the YSL case begin the Monday after Thanksgiving. That's November 27th. We're going to be streaming it gavel to gavel right here on Atlanta News First Plus. Of course, we're going to bring you extensive coverage on Atlanta News First, our traditional broadcast. J. Edward Shipp, our attorney, joining us with analysis. Thank you so much for joining us. Real quick, because every time you do this, people ask, who is that attorney? Can I hire him? How do they reach out?
Hey, they can reach me at J. Shipp Law on Instagram. They can reach me at Jamara Shipp on Facebook. They can Google me, jshipplaw.com. They can reach out 404-507-6773.
Were you
Call
giving
my
your
office.
Oh, okay.
Yeah.
I was like, wow, I don't know about how your wife feels about that.
Not that one. You get the office number. But yeah.
All right. Okay, that's the office
Gotcha.
line.
Yeah.
All right. Well, thank you so much for joining us.
No problem. Anytime.
All right.